afternoon. Thank you so much for joining us. My name is Bridget Bailey Lipscomb, and I have the honor of serving as president of the Women's Bar Association this year. Since 1917, we have learned that many of the challenges we faced then remain the same. So we came up with the theme of getting back to the basics this year. And what a perfect program for getting back to the basics. Effective legal writing, the big picture. We are delighted to have our speakers here today, and let me just take a point of personal privilege. I want to inform you that two of my colleagues, members of my office, will be presenting today. And in my many years of practice, I've had the opportunity to work with countless lawyers. Most of them are extremely talented, but I must say that these two ladies, Caroline Stanton and Marianne Kies, are in the top 5 for writing. They have excellent writing skills. So we're very fortunate today that they are willing to share their successful tips with us. We are in for a treat. Before I turn the mic over, I must take this opportunity to invite everyone here to become a member of the Women's Bar Association. We have many programs like this and activities, and I know there's something that will benefit you. And without further ado, I'll turn the virtual mic over to Bridget Richardson. Bridget?
Thanks, Bridget. It's double Bridget today. Hi, everyone. I'm Bridget Richardson, co-chair of the Career Development and Mentoring and Career Toolkit Committees of the Women's Bar Association. And on behalf of my fellow co-chairs and the WBA, I'm so excited to welcome you all to today's program, Effective Legal Writing, the Big Picture. As our president, Bridget Bailey Lipscomb, just said, she chose for her theme for this bar year, the theme Getting Back to Basics, and what could be more basic or more essential to the practice of law than effective legal writing. I don't know about you, but I will be taking copious notes throughout this program. We have two fantastic presenters that I'm going to turn things over to in just a minute. But before I do, I just have a couple things to go over. First, we'll be using the raise hand function on Zoom for this meeting. So if anyone has questions that they want to ask the presenters, you can just click on the reactions button at the bottom of your screen, and then you'll see a button that says raise hand. You can just click on that. If you aren't speaking, please remember to mute yourself so that we can keep the program moving without inadvertent interruption. Also, I want to thank our sponsor, Sheehan Legal PLLC, whose generosity supported the participation of many of the law students attending today's program. Without further ado, I'm thrilled to introduce our presenters, Caroline Stanton and Marianne Kies. Caroline and Marianne are both trial attorneys in the Environmental Tort Litigation section of the Torts Branch in the Civil Division of the U.S. Department of Justice. Caroline came to DOJ from Cleary, Gottlieb, Steen, and Hamilton, where she focused on complex and multi-district litigation. She also clerked for the Honorable Timothy S. Black at the U.S. District Court for the Southern District of Ohio, and is a graduate of Georgetown University Law Center. Before law school, she served as a legislative aide for U.S. Senator Sherrod Brown. Marianne joined DOJ from Covington and Burling, where she specialized in complex litigation with an emphasis on mass tort defense. She's clerked for the Honorable Michael A. Chigueras at the U.S. Court of Appeals for the Third Circuit and the Honorable William D. Quarles Jr. at the U.S. District Court for the District of Maryland. Marianne is a graduate with highest honors and a member of the Order of the Coif from George Washington University Law School, where she was managing editor on GW's Law Review and was awarded Best Brief and Best Overall Competitor in the Van Vleck Constitutional Law Moot Court Competition. Thank you to both Caroline and Marianne for taking the time to share their legal writing expertise with us. With that, I'll turn it over to them.
Thank you so much to Bridget and Bridget. My name is Marianne. It's nice to meet you all virtually. Before we get started, I do have myself one more housekeeping matter. While we are very excited to give you our tips today about effective legal writing, the big picture, these views are Caroline's and mine only. As Bridget and Bridget already noted, we work with DOJ, but our presentation does not provide DOJ's views. And that's something that we want you all to keep in mind. With that housekeeping matter over the way, this is an overarching principle that Caroline and I both feel very strongly should guide all legal writing, be it an email, a memorandum, or an advocacy brief. Not that the story need be but long, but it will take a long while to make it short. And I think probably all of us lawyers and law students on this meeting have experienced the difficulty of tightening. But again, it is, in our view, the most important principle that you can abide by in any form of legal writing. There are a lot of ways to make your writing stronger for the court or for any reader for that matter. And I think the foundational principle is to be organized. And being organized goes a long way to making your legal writing clear and persuasive. Again, keeping in mind the overarching principle of tightness and brevity. But with that being said, there are, as always, some tips that we can provide to you today that we think, if you try to follow, will greatly improve your legal writing, and in particular in advocacy writing, which is what today's presentation will focus on. So I'm going to give you a short overview now of what those tips are, and then we're going to go into each of them in more detail during today's presentation. Get organized early on. Okay, so that may mean for you an outline, it may mean for you something different, but this is something that should be happening from the very beginning of your legal writing, lest you duplicate effort or spin your wheels. There's nothing more important than knowing where you're headed from the very outset. Put your best foot forward. We'll talk a little bit about this more today, but really what this means is to know what your strongest legal arguments are, to know what your weakest arguments are, to know how they fit together, and to know which arguments simply don't warrant mentioning in the brief, given potential page limits and other local rule requirements. Headings are your friend. Headings help you with organization. Headings help you with overall structure. Headings help show the court where you're headed. I mean, we'll talk about this later today, but a judge reading your brief or a partner or a colleague should really be able to know exactly what your arguments are simply by reading the headings. And we'll talk today about how to get to that point. Headings may be your friend, colleagues, but footnotes are not. We recommend avoiding footnotes, if not like the plague, then like something similar to the plague. As a practical matter, a lot of courts, in my personal experience, do not even read the footnotes. So you really want to think carefully about how you use them and where, how long they are, and how often they appear in your brief, depending on how long the overall paper is. IRAC, I think the law students here are going to be rolling their eyes, and I understand that, but as a practical matter, IRAC, issue rule application conclusion, is a fantastic way to organize your overall brief. Using transitions and topic sentences, this goes to the IRAC point as well. If IRAC is a structure for your overall paragraphs, then using transitions and topic sentences is a wonderful way to move from one paragraph to another. Save the introduction for last. The introduction is the most important way from the beginning of your brief to make it clear to the court or to the reader that the brief is persuasive, has merit, that you really should win no matter what. And so we think that saving the drafting of the introduction for last is probably the most efficient way to get to that point. Once you've outlined all your arguments and have them clear in your head, then it's time to go back to the very beginning. Edit and proof everything. We will belabor this point, but I think the belaboring is appropriate. I think, like anyone, I've been in a position where I'm reading the brief the 19th time, and lo and behold, there are 7 errors on page 1, and it drives me absolutely up the wall. But I think this advice, the reason that the next piece of advice is the same, is just to underscore that you can't read a brief too many times. And we're going to also recommend, and we'll talk about this more, having a fresh set of eyes, whether it's your own or a colleague's, to review the brief again in the later hours. Make sure you've caught all the little glitches. So those are our overall tips, and I'd like to go through them now in more detail. The motivation game. I think we've all been in a position where a motion for summary judgment needs to be written, and what do you have in front of you? You have a Word document that is blank with a little cursor that's blinking angrily at you. I hate this moment. Everybody hates this moment. So what are we going to do to get you past this moment and on to drafting? Well, like I said at the beginning, getting organized is going to be useful in a number of respects. And one respect is it simply helps you put pen to paper without feeling that paralysis that we've all felt in the face of a blank document. And I want to underscore, I think, some institutions, really do emphasize the importance of outlining, and I don't disagree with that, but I really do think it's important when you're writing a brief to make it your own and to prepare whatever way makes sense for you, right? You don't want to be trying to fit a square peg in a round hole. And if you don't like outlining, that's fine, don't outline. But that doesn't mean, having no plan of attack. So you want to know a few important things before you start writing, and you would like to ideally put these issues down on the page. What are the issues that your brief or your paper is going to be addressing? What are your best arguments? Why do you win? What isn't worth including? And what is your page limit? And this page limit point, I really can't emphasize enough. I feel quite strongly in judicial papers that a page limit is not aspirational. It should not be your default to ask for an extension of pages. Frankly, a lot of courts aren't going to grant it anyway. And more to the point, if you need more pages, I think that is likely more a factor of the writing than the issues. I've seen, incredibly complex cases prepare a motion for summary judgment with a ton of evidence and a ton of legal issues that are still 35 pages. You can do it, but it does go back to that foundational principle. It's got to be short and you've got to take time to get it there. So they're not aspirational. Obey your page limit. If you really want to impress the judge, try to go a little bit under.
Marianne, hi everybody, this is Caroline. I just want to add one point on the page limits. For anybody who's clerked, you get a lot of requests for an extension on page limits. Page limits are usually driven by either the court's local rules or the judge's standing order, right? And like Marianne said, some judges will just deny it, right? Some judges will grant it, but the number of times I worked with my judge where we granted it and then we all talked smack about how plaintiff's first initial thing was that they couldn't follow directions. It's just not how you want to start. And everyone I've worked with over the years, right? You're like, I have a 200-page complaint. Surely I need a page limit extension because my motion to dismiss is so special. You're not special, okay? I don't mean it. It's not. They have a standing order, that's it. And even if they grant you an extension, they're probably only going to read the first 15 pages or whatever the page limit is, right? So think about it, spend your client's money wisely, spend your time wisely, and whatever you do, if you ask for more page limits and the court does not rule on your motion before your brief is due, don't just assume they were going to grant it and write what you wanted. Okay, because that is just a recipe for being embarrassed later. Don't do that.
These are all incredibly helpful tips and tough love and 100% accurate. I completely agree with everything Caroline said. Brevity is so key. Not just brevity, but understanding the priority of the arguments that you want to make is really important. I think all too often, I'll see folks kind of, say there are 10 issues in a case and they'll just go 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 with seemingly no regard for what issues are best for their side and which ones are frankly, if not meritless or frivolous, pretty close to it and just don't deserve the attention. I think you really can improve your credibility in front of the court if you show the court that you appreciate where you're likeliest to win and where not. And further to this organization and page limit point, you don't really want to waste 3 of your 15 pages on issues that you probably aren't going to win when you could devote them to making your central arguments that much stronger. So obviously there's all kinds of client and other sensitivities that go around what arguments to include. And I'm not saying you just drop one, but just keep this in mind. You want to argue your case affirmatively. You also, by the same token, do not want to be bound by what the other side is arguing. And I think this is probably more true if you're in the position of writing an opposition letter as opposed to an opening brief where you have a little bit more leeway. But the other, I think, I'll call a faux pas that I see in legal writing is if your opponent has written an opening brief and they line up the issues as 1, 2, 3, 4, that does not mean that in your opposing brief you need to similarly respond in kind. You want to still put your best arguments first. I mean, certainly, you want to address any weaknesses that your opponent may have identified in some of your arguments, but don't feel bound to take the approach that they took. Make your brief the best brief that it can be. Use your space well. And here's a personal favorite I think Caroline will probably chime in on as well, is not to engage in personal attacks. I think we've seen briefs where this guy did this and she didn't respond to my email, and 6 times I tried to get an answer on this, and you guys, the judge doesn't care. And also the judge is going to feel like it's a petty little dispute, between kids as opposed to a professional, presentation by the lawyers. And I will tell you, even if the other side has engaged in this kind of poor behavior, you will absolutely look the better lawyer for taking the higher ground, and the judge may even subconsciously feel more inclined to read your arguments with a close eye, knowing that you're making arguments based on facts and law and not casting aspersions on another individual. Caroline, do you have any horror stories in that regard?
Yeah, no, I mean, I think that's definitely true. And, I think that, first of all, opposing counsel can be really difficult. And it's perfectly normal to find them super obnoxious and have some personal animosity sometimes, but you got to keep it out of your writing. And you also, one of the things that goes with this is just be really mindful of who you're speaking for, right? And if I engage in a personal attack, not only is it unprofessional, but oh my God, the United States did blah, 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 right? I'm just held to a different standard because of who I represent. And so not even personal attacks, but just be mindful of how what you say reflects on your client. And you have to think about it. But I think the personal attacks, this is really hard. And my advice here is if somebody attacks you, write your strictly factual defense to it in your first draft, and then figure out later whether you need to keep it, right? But because it's really hard, you don't want to let it slide when somebody just says you did a whole bunch of things, right? But general rule of thumb is if they accuse you of violating Rule 11, respond to that, right?
Sure.
If they just say you were rude, ignore it. That's my...
That's 100%. That's a totally fair caveat. And I do think another fair caveat is if you're in a motion to compel situation where this type of procedural history and any kind of dilatoriness or withholding, of evidence unfairly is actually directly on point and relevant, that could be a situation where a little bit of this type of procedural history as well. But keep it bare bones, keep it factual, and don't let yourself slide into anything that veers towards personal is my advice. Speaking of the facts, I think fact sections of briefs often are a missed opportunity for lawyers. I think, when you think of a fact section, you think, oh, this is just where we say kind of this happened and then this happened and here we are today filing a motion. But in fact, the fact section is a really great opportunity to start making your argument. Do you make it an advocacy piece of writing akin to an argument? No, of course not, because you don't want to be accused of spin. But on the other hand, facts can be laid out in such a way as to show the court, even before you get to your argument, why, given all of them, you should win. So how do we get to that point, given the overarching principle that we began with of keeping it short? Well, first things first is don't include unnecessary facts. So if it's a motion to compel, like I said, maybe the procedural history there of what has been happening in discovery a little bit could be important. But if it's a motion for summary judgment, you want to get right into the issues that matter, that will, when incorporated into the argument, show the court why, as a matter of law, you prevail. So you don't want to include facts that are unnecessary, that clog up your brief and don't get right to that point right away. You do, though, want to be aware that you should not be including, legal jargon or kind of terms of art in your fact section without explaining what those are. So I think, that's not necessarily contrary to our advice to keep it short. It's just a common sense point where if you want to make sure that the court can tell that you win, you have to explain the intricacies of the phrases and terms that you're using that may be at this point very familiar to you because, it's a patent case and you're a patent lawyer. But just keep in mind that courts are not, and they're new to this case. And so you want to write your facts so that someone new to the case can understand them. Like I said at the beginning as well, striving for a narrative, whether that means organizing your facts maybe it is chronologically. It certainly depends on the facts of the case. And I don't want you to be afraid of saying this happened and this happened. But, if you're going that route, make sure it's not reading as a sort of a plotting on this date, this, on this date, that, as opposed to an overall narrative that is really painting a picture for the court. Okay, so I think we had promised to you all that this presentation would be interactive. So here is your moment to interact with us, and we would really appreciate your views on this hypothetical motion for summary judgment. I'm calling it fact sample number 1. So I'll give you all a minute to read it before I move to the next slide. Okay. So in the chat window, which I have been reliably informed is at the bottom of the window, but certainly speak up if you don't know how to do it. Let us know what you think is wrong with fact sample number 1 and what would you do to improve it, given the things we've been talking about. Okay, see transition words.
Hey, Marianne, can we go back a slide to have it show while people are commenting?
Absolutely.
Just to get it started, because thank you, Jordan, for chiming in. So my very harsh assessment is it's all terrible and I would just delete it all, right? Like it totally has nothing to do with the motion for summary judgment. I don't care that you had a discovery dispute that is now over. I don't know if that was Marianne's point, but that's my vibe.
Yeah, and I think, no, it is. It's 100% terrible. I just got a message as well from Leah. It's really dry. It's not engaging. There's no narrative. That's absolutely right. I mean, if you read it out loud or even in your head for that matter, what I hear is da, 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 da. I mean, it's nothing. It's just fluff. And for a motion for summary judgment, you want to come out punching, right? And so, make it punchy, don't make it plotting, particularly because as Caroline noted on an MSJ, none of this, sort of by definition matters. So totally agree with everything that she said. Okay, here's one more for you all to chime in on, given what we've been talking about, and I'll leave this open for a couple minutes. And the next question that I'm going to have for you, like before, is what is wrong with it? What would you do to improve it? Yep, Lakshmi got it. It's a personal attack. It's actually 2 bad things. It's just as boring and unnecessary as, no one cares about. I love these. These are great. No one cares about your difficulties with other counsel. Correct. Yes. All of these comments are 100% on point. No relationship to the motion for summary judgment. Nobody cares about your difficulties with opposing counsel. Doesn't advance the argument. All of this is absolutely right. Do not include this paragraph or anything like it in any motion for summary judgment that you ever write. At most, this type of an argument is going to appear in a Rule 11 motion, which I really, really hope nobody ever has to file.
The other thing I would say about this is even if all this is true, I don't understand what it is that they did, right? They've just had right? It's not like they failed to provide discovery or they didn't produce a witness or they lied to the court, right? It's just a bunch of like blather that they're terrible, like without any specifics.
That's what Jesse just said too. Plaintiff counsel was able to collect all the evidence anyway. So it's like no harm, no foul. Why is this here other than because it makes the writer feel better about complaining?
Yeah, and we'll also talk about this a little more later on. There's way too many fancy lawyer words in here. Like endeavored, undersigned, don't use any of this.
Judicial intervention.
Yeah,
Otherwise
just make it all
resolvable.
stop. Yeah.
Yeah, cut this paragraph and never. Okay, good. Well, I'm glad we prepared a terrible paragraph at least. Okay, I'm going to at this point turn the presentation over to Caroline to understand what headings are your.
Thank you, Marianne. Okay, thanks everybody. So headings are really important and you probably have to write them several times. Point headings, you're supposed to organize your argument section into primary parts. It should be a concise and conclusory statement that is a complete sentence. So keep in mind the rules. Don't write your headings in all caps because you're not yelling at the judge, right? That's different than like, if you have something that just says like argument, right? Like that's fine, but don't be like, I should win because, right? Like no one wants that. Should be declarative. And some of these rules are also, easier said than done, but you have to provide enough detail, but it's a sentence, not a paragraph, right? So try to keep it short, 2 sentences. Use consistent styling throughout. I'm here to tell all of the law students that the Blue Book is sort of a reference guide in real practice. Lots of people don't remember the rules, and your biggest thing is you just need to be consistent, okay? So next one, this is an example. And so the United States is entitled to sovereign immunity. Okay, that is a complete sentence. It is declarative. It's not the worst heading there ever was, but it's not the best, right? Because it doesn't really tell me why or how you should win. The second one is a little longer, right? The United States is entitled to sovereign immunity because EPA's regulations give on-scene coordinators broad discretion in performing their work with circle sense. So the reason this is a good heading, although it's a little long, you could trim it, is if you read this, you know my whole argument, right? Like that's why I should win. And it's easy to remember, and it conveys the argument, the legal framework, and the key facts. Okay, this next slide. So this is the table of contents from a brief that one of my colleagues wrote. And the reason I use this as an example is you can just read this table of contents and you understand the whole argument and why we should win. And sometimes people will write examples like, if the first heading were just like, plaintiff has no standing, well, like what exactly is your argument here? Like now I gotta go read it and flip back and forth. That's annoying, right? The whole goal here is to make it easy for your reader. So think about it that way. And so my overall tip on this is read your table of contents when you're done. And can I follow your argument that way? And if I can't, rewrite your headings. Okay, footnotes. Marianne talked about this already. They're terrible, okay? People don't read them. If your argument's in the footnote, probably not worth making. If your footnote is like a whole paragraph and breaks across pages, it's just like painful, and don't do that. There's a few exceptions, I think. First, our really long citations can be in footnotes, right? And particularly in the kind of practice Marianne and I do, when you're like, the comprehensive environmental regulation of 1981, public law 1, 2, 3, 4, 5, 6, 7, USC, like it's so long. You can put that in your footnote so it's not like blocking up your text. Footnotes can be useful to respond to an opposing party's argument or to note that they agree with you and you don't have to make the argument, right? Like footnote 1, plaintiffs have abandoned their claim for negligence, right? Cite their brief. Then just move on. Also, some people really love footnotes. This can be really difficult when you're on a team, right? When you're like, take this argument out, it doesn't belong here. And their solution is just to put it in a footnote. If somebody's going to put it in a footnote and it's a bad argument, it's better that it's in a footnote than it's in your text, right? To keep the peace. That's my team management advice. But just in general, try to make them small. Try not to use them. And if it's important, it doesn't belong in a footnote. And if it's not important, it doesn't belong there at all.
Yeah, and I mean, to Caroline's point, what she just said about footnotes being useful to respond to an opposing party's argument, I really, really like to do this, not only because you know, it's just it saves the space and it leaves you time to be putting your best foot forward as opposed to trying to do whack-a-mole with their arguments, but it also, you know, reading between the lines, it kind of signals to the court that, you know, this argument is so silly, it doesn't have any merit, there's no case law to support it. Whatever your response is, just the fact that you put it in a footnote shows your confidence about your own arguments, and the fact that, you know, what the other party said about A, B, or C, just, it really doesn't matter. Don't worry about it. It's in a footnote, Judge. It's a footnote point. So I agree with that. And I really like to use them that way.
The one thing I will say about footnotes though, is read some of the opinions by the judge in your case and always read your judge's footnotes, right? Because sometimes judges like to put points in there, like, you know, counsel for both parties failed to find the opinion by this court that is directly on point. That, like, right, that's important. And so see how the court uses footnotes and sort of bear that in mind accordingly. But all of these rules overall, also, they don't apply to judges. Judges do whatever they want, so read all their footnotes.
100%. You might find some useful dicta in there too, you never know.
Yeah. IRAC. So for everyone who's been out of law school or LRW for quite some time, this is issue, rule, application, conclusion. You just need to be mindful that there is a point to your paragraph, right? What is the issue? How do we decide it? How does it apply to your facts? And why do you win? So this is an example of IRAC. You all can just read it, but the first boxed sentence, there are some issues or some jobs that a lawyer has, right? That's the first, that's the issue. And then there's the first, these are the rules and application. I actually don't think this is the best example, but the point is you can follow this paragraph. And it's easy to follow, it's easy to understand. But make it clear. Perhaps this is obvious, but transitions are important. Use them to clarify why you're switching from one to another, but don't overuse them. Make sure, however, does not appear in your brief 18 times. Make sure moreover doesn't appear ever. You know, just make sure you have transitions between things and make it flow. Again, easier said than done. So you can have pointing words, you know, this, that, these, those, echoing phrases, you know, similarly, likewise, connectors, you know, further, in addition, contrasting connectors, but however, nevertheless, etc. You know, when you read your brief and it seems disjointed, like that's generally a problem where you don't have enough transitions, or it's not clear why the second idea follows from the first, right? So, and even though it seems really elementary, but it's okay to be like first, second, third, right? Like you have to do this, you have to do that, you have to do that. So follow those.
Sorry,
I see the
Caroline.
comment. I'm sorry,
Yeah.
go ahead, Mary.
No, do you want to? I wanted to make sure you saw it so you could, if you want to take a crack.
Yeah, so restating the rules without being repetitive, that is a great question. And this also goes along the lines of your topic sentence and your heading should not be the same thing. And it can be hard. I think the rule, you know, the issue is sometimes the issue and rule end up sort of being condensed into the same paragraph, right? You know, to demonstrate negligence, you must show duty, breach, proximate cause and harm, right? That is both the issue and the rule. So I think sort of consolidating them together is one way you can do it. I don't know, Marianne, do you have other thoughts?
Yeah, I mean, I think if you're thinking about, I like this example because I think everybody knows duty, breach, cause, damage. So let's go with that. So let's say that, you know, you're saying whatever, we were not negligent and here's why: no duty, no breach, no cause, no damage. If you're setting out under point 1, let's say it's a Roman numeral 1, we client are are not liable for negligence because there was no duty breach, cause, or damage. When you go to subpart A, which is going to be presumably there is no duty, you don't need to start that subpart A by saying duty is the first element, you know, of negligence and there was none. You just said that. You can just dive right into saying, you know, so-and-so is had no duty because yada, 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 cite case defining what the scope of the duty is and the type of issue that you're dealing with. So I think I understand what you're saying, Ellie, because there are situations where you get so hooked on the IRAC that you find yourself saying the rule at every single level and sub-level of the brief that you're writing, which you don't need to do. I think the overarching point is to try to incorporate IRAC into your brief structure overall so that each section, like Caroline said, has a purpose and fits together and it's clear why the pieces of the puzzle are there and you have an argument and a conclusion. But I wouldn't follow it religiously. And one way, you know, to deal with this issue is to start in your first draft by making it very structured and rigid, but then your second, third, fourth, fifth, sixth drafts, go back, right? And add in a little more of your argument, add a little more persuasion and use some, you know, great language that makes it not repetitive. And I think by the end of the day, where you should end up is in a place where it's just as clear as it was at the beginning, where you're headed with each argument and sub-argument, but by the same token, you're not like just restating again and again the elements of the rule. You know, does that, I don't know if that makes sense. I think it's a good organizational tool, IRAC, but don't follow it too closely and feel bound to it that rigidly.
And with regard to Rachel's question, my beef with moreover is it's not a word anyone actually says in conversation, right? And it's a word only lawyers use. Like, I'm totally guilty of using it in briefs. Other people do. But we'll talk about this more. I think like the goal is to sound like a person, not a lawyer. So I think sometimes you have to use it, but think about like, if you were trying to have a conversation, would you say that word?
I mean, it's funny. Caroline and I think I'm not quite as like morally opposed to moreover. I think it can be useful because, you know, remember one of the other rules is not to use the same transition words again and again and again. So if you're doing first, second, third, first, second, third, first, second, third, you know, the judge is going to say, oh gosh, what is the first, second, third? I've already seen 4 first, second, thirds, you know, so what's the first here? So I find it can be a helpful tool, you know, stylistically to kind of break up that type of language. Instead of saying first, second, third, say, you know, as an initial matter, moreover, finally, right? You could also use further. I think further is a little bit more colloquial in an appropriate way than moreover. So for whatever that's worth. I suppose reasonable minds can differ.
Yeah, it's totally just like a personal preference. There's no real rule. Okay, the next slide is, this is a little bit what we just talked about, like introducing paragraphs and topic sentences. So, you know, you want to announce what the paragraph is about and why it's important, right? So the way we talked about the introduction sets the tone for your brief, the introduction also sets the tone for your paragraph. And so you need to concretely frame the issues, summarize why you win, and explain the relief you seek. That's sort of your big picture introduction. So this slide, right? The United States first served its discovery request 18 months ago. Despite the benefit of repeated extensions, none of the 15 plaintiffs has produced a single document. The court should grant our motion to compel because I like this because you already know why I should win before I even say why I should win, right? And I think this is a good example of how to clearly state facts while avoiding ad hominem attacks, right? We didn't call anybody lazy or dilatory or flouting the court's rules. Is more just like, dude, they're really late here and they were required to give me this, so make them. That's that. Okay, next one. This, please don't ever write anything like this, please. I know, particularly for people who have sort of institutional clients, like the government or firms, you have a lot of templates. Templates can be bad. Okay, that's my other pro tip. Some templates are wonderful, but just because everybody always did it that way does not mean you should always do it that way. But it's also like, it hurts to read. I don't know what the point is. It's long. It wastes a lot of space and it doesn't really say anything.
It violates all the rules, guys. All the rules are violated.
Okay, this is probably my pet peeve that I bring up all the time. No fancy lawyer words, okay? It needs to be easy to understand what you're talking about. And that doesn't mean that opposing counsel and the court and everyone are not very well educated, great lawyers, very smart, okay? But you don't want it to be hard to read or hard to follow, right? So, you know, the gravamen of plaintiff's complaint is that although they endeavored to meet the standard of blah, 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 okay, plaintiffs tried and failed. That's what you're saying, okay? Just cut it down. You know, a standard somebody you told me once is like, try to explain it to your mother, right? And if she doesn't know what you're talking about, then try again. And you know, this is assuming your mother is like a smart, educated, accessible person, right? And it's not a dig on anybody. It's just about making it approachable. So, you know, words like gravamen, endeavor, etc. My standard from before, like, is this a word you would use in conversation? Then it's okay. If it's a word that you or anyone on your team has to look up in the dictionary, please don't ever use it in your brief. That is an argument I used to use with a partner I worked for, that if I had to find a dictionary, he wasn't wanting to use it. So be careful of internal references, okay? Like, to save space, sometimes people will be like, see section 2.3c. Like, what is that? I don't know, right? And now I'm back to your table of contents, right? So, or, you know, a lot of supras and infras, like, you don't need to repeat yourself, but you do need to be careful with how you refer to prior things. The biggest issue where I see this is in reply briefs, right? Somebody says, I already explained this in my opening brief. I'm not going to waste space saying it again. Reasonable minds can differ on whether that is appropriate and it's really sentence specific, but if you're going to do that, at the very least, you need to say, like, see motion at page 2 to 3, right? Don't make somebody have to hunt for whether you said this before. Be sure to define commonly used terms. I think all of us who have practices that focus on particular areas are guilty of sometimes failing to see the forest from the trees and getting really in the weeds. So for example, like, a lot of people in federal tort cases say, well, you know, the contractor exception. I don't know what that is. Do you know what that is? Right? Like, that refers to a particular section of the Federal Tort Claims Act that says, you know, the United States has not waived sovereign immunity for claims premised on the conduct of non-governmental employees. Okay, that's like long-winded, but instead of saying, you know, plaintiff's claims are barred by the contractor exception, you should say the United States has sovereign immunity because plaintiff's claims are not against United States employees, right? It gets to the point more directly. A couple of questions. Do you ever adjust your writing style to match a judge's preferred writing style? Yes. However, what that means is not, I still don't use a lot of footnotes. Unless the judge always puts their citations in footnotes, then I put my citations in footnotes, because that means that's like a style citation thing, not a writing style thing. And then if the judge uses a lot of jargon, that is the judicial prerogative of a lifetime appointment. I will still never use jargon.
Yeah, I totally agree with that. Because for all you know, the reason the judge uses jargon is because he or she was given a wonderful legal brief by Caroline Stanton that explained all the jargon, you know?
When you say you shouldn't write an opening paragraph, comes now, etc., what language do you suggest? I think you can look, you know, it just needs to say, like, you don't need that paragraph generally, right? You say, like, the United States, like, you know, pursuant to Rule 56, the United States moves for summary judgment. Like, yeah. I think that you can look for stuff that way. There's a lot of great examples out there. You know, I'm a government lawyer, speaking in my personal capacity. The briefs in the Solicitor General's office are amazing. They're also not just for the Supreme Court, which is a very specialized practice, but there's lots of briefs for the circuit courts up there. They're all exceptional writers. So I would look at those as examples, but, you know, just try to use other sort of, you know, regular words.
Yeah, and I mean, the only, this isn't a caveat, but it's a clarification that we mentioned before with respect to the page limits. The local rule should absolutely always be the local rules, and then your judge's standing order should be your starting point. So I know certainly in CD Cal, probably other federal district courts in California, because their formatting is so, let me just say it's interesting. And so they have, these various requirements that you have to satisfy. And I think there are somewhat more rigid requirements as to how you present the motion that accompanies the memo ICE of the motion. So obviously this is not to say ignore the local rules and write whatever you want. If they have a specific set of requirements, make sure to include them. But if that's the case, I would still do what Caroline said. And if you're at a firm, at the government, wherever you are, public advocacy organization, go to a piece that a colleague has written that, who you respect and whose writing you admire, and see how they approached it. And just remember that the overarching goal is to be persuasive, especially in your advocacy writing, and don't do anything that contravenes the local rules, but to be consistent with them doesn't mean you have to let everything else fall by the wayside. That's kind of what I would say there.
Okay, can we go to the next slide, Marianne?
Sure.
Okay, edit and proof, and then again and again and again. So what do we mean by proofing, right? Cite check. So do not selectively quote a case that's unhelpful to your own position, right? So there's a really good phrase, but if you read the rest of the paragraph, like the side arguing your position actually lost, right? Don't do that. And make sure you have a table of contents and a table of authority. You follow all the special rules and that they're right. Look for spacing, consistency, font size, the type of consistency, grammar, widows or orphan headings. Another thing that I think is really difficult, particularly for more junior lawyers, especially if you work at a firm or in a place where there are many cooks in the kitchen on a given brief, right? Like you, associate, write the brief, and then a partner reviews it, and then the client reviews it, and then another partner reviews it, right? Read the whole thing, and first of all, make sure it sounds like one person wrote it, that it wasn't drafted by committee. Second, not to be like doomsday, but like you really got to make sure nobody's accidentally violating Rule 11 here. Because what happens is associate researches, finds a case that supports what you say, and you say, similarly to this case, we should win, right? And then 3 people later in the editing, it now says, this case absolutely says the Supreme Court says I should win always, right? And nobody else went back and read that case originally, right? So you're like, oh, wait, actually, that's not what that said. So the more time you need to leave to, the more people involved in editing, the more time you need at the very end. And not the topic of today's presentation, but this is sort of a life skill of upward management. You have to tell your boss when they have to stop editing. So yeah, I think that is very true. And then I think, Marianne and I talk a lot about making sure you have plenty of time to proofread. And, Marianne made a reference a few minutes ago to like the 6th draft. And part of me wanted to laugh because like, I've never had time to write 6 drafts of a brief. And a lot of people are really pressed for time. So like, what do you do, right? So 1, have a colleague who's not on your case read your brief, right? Or if they are on your case, but they didn't write your brief, just have somebody, not in the weeds read it. That's good. Second, I make a list of things that I check for when I proofread, right? I always search my briefs for the untied states because that does not show up on spell check. Little things like search like that, search for your apostrophes and make sure they're all in the right place, right? Search for making sure you have the same number of opening and closing parentheticals, right? Like those kinds of things. Like if you just make yourself a cheat sheet, it doesn't take that long to go through those. And you will catch most big things, even if you don't have time to like read it again and again. But I think if you're really pressed and you don't have time to do all the things we told you to do for proofreading, cite check, don't commit Rule 11 errors. That's number 1. Number 2 is fix your headings. Spend all your time, that's where I would devote my effort. And then, search for like the most common typos and grammatical errors.
Yeah, I think I think all of that's really important. I mean, I think, and I don't think we explicitly said this, and perhaps it's hopefully obvious, but, we're not recommending proofreading just because, we're anal retentive. I mean, this is super duper important. I am anal retentive, but this is super duper important for writing because, even though you might think it's superficial, the fact of the matter is a judge who sees a brief that is replete with grammatical errors, God forbid, kind of miscites a case or treats it unfairly, is going to have an immediate reaction to the scope of the rest of your brief, fairly or unfairly, and consciously or unconsciously. As a clerk, I experienced this. I know that my judges did too. The briefs that are well put together signify to the judge that the lawyers are careful, and thereby that probably the arguments they're making are careful and well thought out and supported as well. And so don't, I wouldn't, like Caroline said, sometimes you're in a situation where you don't have a choice, but if you have a choice, do not give this stage short shrift. And absolutely, if you have time, take 24 hours, read it with your own fresh eyes, ask somebody else whose eyes are fresher than yours because they weren't up until 3 a.m. To read it for you. And just keep in mind that it's absolutely worth it. At the end of the day, you want your writing to be accurate, but you also want it to be persuasive. And at least personally, I kind of think of legal writing or any kind of advocacy writing as a type of music where you don't want it, just to have a beginning, middle, and an end, and it all fits together, and that's great. But the things that really move you are because they're elegant, and they ebb and they flow, and there's crescendos, and it's just you when you're finished reading it, or in music cases listening to it, you think, wow, that was super duper powerful. And the way you get to that point is not only by making it organizationally sound, but making the writing superb. And the way you get to that point is by taking your time and going back again and again if you can. So that is my final thought, and I want Caroline to also give any final thoughts, and of course, if folks have more questions, to have time to address those.
No, I think I've said, all my main thoughts. Does anybody have more questions? And again, a lot of this is like, do as I say, not as I do. Like, it's really hard to do all of this all of the time.
True. But do it.
All right. Thank you so much, Caroline and Marianne. This was fantastic and really informative and really helpful. I'm Deborah. I'm with the Career Development and Mentoring Committee too. And I think we have a little bit more time to open up for questions. And so why don't we start with Ellie? Why don't you unmute yourself and go ahead.
Hi. I'm only in my second semester of law school, and I'm a part-time evening student. And I'm sort of pressed for time anyhow, because I have a child and I have another one on the way. Was there anything that you found particularly helpful during your law school years to help you really hone in and drill your writing skills?
So first, I will say I just have a soft spot in my heart for evening students because I was one too. So more power to you. I think that for me, part of it is my day job gave me some time to work on my writing too. So writing is writing. So don't feel like that. And then the other thing that I found helpful in law school, particularly like when I was pressed for time, is, like, don't let the perfect be the enemy of the good. Like, I have 3 hours today to work on this brief, and I'm just going to work on it for these 3 hours. And if what I have at the end of it is terrible, that's fine, but I have something. So give yourself like a block of time and then a break, and then come back to it. So it's always easier. And then also read, like, in your abundant free time. I like to read like Supreme Court decisions because they're fun and interesting and they're relevant to school, right? But they're also, a lot of the justices or their clerks are really good writers. And so they're interesting.
Yeah, these tools will become second nature the more you do it as well. And I really do mean that. And so it might seem a little bit, plodding of an exercise, but, I think, the good writers are just the ones who do it more and more and more. And so this becomes like an instinct as opposed to a kind of a set of rules. I think the other thing that really helped me in law school was I would actually write out, so embarrassing that this is being recorded. I would write out, like hour by hour blocks of what I thought was achievable. So like, let's say I had a window from 7 to 9 p.m. to do something. I would just tell myself in this 7 to 9 p.m. no matter what, I'm writing the introduction, or I'm going to write subpart 1A, because it's obtainable, because it kind of lowers the pressure of that terrible blank page or the skeleton outline with the blinking cursor. And then at the end of it, you feel like I've accomplished something, and then the next day it's a little bit easier. You can always try incentives. They work for me too if you're having that motivation issue, where it's like, if I write the introduction by 9 p.m., then I'm going to have I don't know, a piece of chocolate, whatever your thing is. Like, but truly, I mean, we're all human. Act well to self-bribery. So you could try that. I think Chrissy has a question.
Yes, hello, thank you. So I, first of all, want to thank you. This was so informative and helpful. I am a paralegal student at Nova. I have about 5 classes left, and kind of a midlife COVID career change move on my part from a very different career. And I love it. I've always had an interest in law, and I'm so excited to be able to delve back in it in a way that's going to work, I think, best for me and for our family. I am curious how you utilize paralegals to do with your writing. Like, are they drafting any of the things that you talked about today? Or how are you utilizing them in the writing process specifically? Because I know I just finished legal research and writing classes the last semester, and have all this great knowledge I want to put to use someday. And so I'm curious how you guys work with your paralegals for that. Thank you.
So this probably varies a little bit place by place. I tend to do my own drafting. Paralegals do a lot of they design the templates, which is super helpful. And they do a lot of the proofreading for us. Site checking is typically not a task you can assign to a paralegal because they are not an attorney, and depending on your jurisdiction, you could have issues with the bar about whether somebody adequately made representations. But I think you can absolutely have a paralegal do research for you, or draft. We have them draft memos a lot, like not briefs, but what is the research on this? What does it say? Where do we do things like that? So that's how I use them. But Marianne?
Yeah, research for sure. Site checking in terms of blue booking, making and proofing the overall structure and the writing. And I agree with Caroline. I think it just does depend on the jurisdiction and the place. I mean, I never had any issues and have asked paralegals in a past life to site check in terms of does this case say what the brief says it said? And is there any, negative history, in which case the paralegal could shepherdize it and find, the yellow flag or the red flag, and provide the case that Westlaw or Lexis reflects, contains that negative history, and the lawyer can decide, what the consequences of it are and how to rewrite the brief if necessary. But I mean, all of that, like Caroline said, is absolutely essential, as well as the templating. And in that case, the paralegal is responsible for finding, the local rules on formatting and structure and how to deal with exhibits and redactions and motions to seal and all of that stuff that is just incredibly important. And if you do it wrong, your brief gets kicked, and maybe worse than that. And so they're essential, but I think you have to be careful, like Caroline said, with, practice of law, things like that. Pierre.
Thank you.
Sure.
Yeah, and I think Pierre will be our last question because we're, I think, running up against the clock here. So, and he also included it in the chat box as well.
Oh. If you enumerate all your paragraphs, what is the downside of? Okay, so Pierre asked if you, oops, I just lost it. If you enumerate all of your paragraphs, what is the downside of referring to previous paragraphs and putting forth new arguments and incorporating the basis in past paragraphs? When you say enumerate your paragraphs, do you mean literally like in a complaint?
No, I think this is like my example where I was like, don't write C part 2B, 2CB, right?
Oh, okay.
No, what I meant basically is when I write a brief, I enumerate all the paragraphs, so that way one can refer very quickly to different sections of the brief. So the question is what is the problem with cross-referencing things that you've already said and incorporating them in a new argument by referring to the previous parts of the brief, but then using the enumeration system.
Oh, interesting. I mean, that may just be I haven't personally seen that before. I think it is a slightly different situation. I agree with you. If every single paragraph in a brief has a number assigned, it could be pretty obvious, more obvious than normal, what you're referring back to. I think the point is more important to bear in mind when you're going across briefs as opposed to within briefs. So the issue that Caroline was talking about with supra infra, that's more just like a stylistic, and it just kind of breaks up the flow of your writing if you're constantly saying, as I already said in paragraph 3, as previously discussed in paragraph 2, versus the more important substantive issue when you're writing a reply brief and referring back to your opening brief, just making sure it's very obvious what you're referring back to, and maybe even having an explanatory paren in case the judge doesn't want to go back to that opening brief, but can simply sort of refresh his or her mind. Oh, that's where the lawyer was saying that there was no breach because A, B, or C, if that makes sense. So I think you're right. In other words, in terms of it's less of a concern for within a brief if you have the numbers and it's clear, what you're referring to. But stylistically, I would try to avoid that type of repetitive internal cross-referencing.
Thank you.
I agree with all that. And just before we close, I wanted to give one reference back to the question of what can you do in law school? If time allows, one of the best things I did in law school was internships and externships. Federal clerkships are really hard to get, but a lot of judges will take volunteer judicial interns, right? Where you can basically be like a baby clerk. And legal writing in law school is always like from this preformed set of facts that coincides nicely with the elements of the claim, right? So it gives you more real world experience and you can do it. And it's hard, you're not always paid, but you can get externships or you can get equal justice works opportunities. You can get credit. So that's definitely a thing I would suggest. And I'm also happy, we're out of time, but I think somebody asked if we could circulate the slides. We can follow up with WBA on that. We can circulate the slides. You guys can always reach out to us if you have additional questions.
Oh, for sure. If you have I don't know if you have our contact information, but I'm happy to answer any writing questions. Maybe the WA knows that answer if that was provided.
We will follow up with everyone and take care of that, circulate the slides. And thank you both again so much. This was fantastic. And thank you to both Bridget for introducing and the Career Toolkit for also co-hosting this event. And we hope that you will all join us for another event soon.